Good afternoon. The following are the questions asked to be answered by the students in Civil Law Review 2020 of the University of the Cordilleras, Baguio City. But before I will answer these questions, I would like to take this opportunity to thank our humble, hardworking, and dedicated Professor Attorney Castro for the unending effort in helping as her students in civil law review. Thank you and good luck. See you soon, ma'am. Now, let me start by answering the questions in civil law review. First questions is that may entries in the birth certificate as to first name or sex be changed on the ground of equity? The answer is that no. Entries in the birth certificate as to first name or sex cannot be changed on the ground of equity. In one case decided by the Supreme Court, it held that there is no legal basis for his petition for the correction or change of the entries for his birth certificate. The Supreme Court also said that neither may entry in the birth certificate as to the first name or sex be changed on the ground of equity because the changes sought to by petitioner will have serious and wide-ranging legal and public policy consequences. And one of the consequences is that to grant the changes sought by petitioner was substantially reconfigure and gravely out of the law on marriage and family relation. It will allow the union of a man with another man who undergone sex reassignment, a male to a female post-operative transsexual. Moreover, it will go against the provision of the Family Code on marriage, since marriage under the Family Code provides that it is one of the most sacred social institutions and a special contract of permanent union between a man and a woman. One of its essential requisites is the legal capacity of the contracting party, who must be a male and a female. Thus, allowing the petition for correction of entries in the birth certificate as to first name or sex on the ground of equity will go against the very purpose of the law, especially the legal capacity of the contracting party on marriage. Next question is, what are the essential requisites of a valid marriage? The answer is that the following are the essential requisites of valid marriage. 1. Legal capacity of the contracting parties, who must be a male and a female. And 2. Consent freely given in the presence of the solemnizing officer. Next question is, how does law define legal capacity? The answer: the law defines legal capacity of the contracting parties as any male or female of the age of 18 years or upwards, not under any of the impediments in Article 37 and 38, may contract marriage. From the foregoing, a father who marry his daughter-in-law after the death of his son is valid, because the law is silent on this under Article 37 and Article 38 of the Family Code. Next question is, what are the formal requisites of marriage? The answer is, the following are the formal requisites of marriage pursuant to Article 3 of the Family Code of the Philippines. 1. Authority of the solemnizing officer. 2. a valid marriage license, except in the cases provided for in our Chapter 2 of this title, and 3. A marriage ceremony which takes place with the appearance of the contracting parties before the solemnizing officer and their personal declaration that they take each other as husband and wife in the presence of not less than 2 witnesses of legal age. Next question, what are the effects in case of absence, defect, or irregularity in the essential or formal requisites of a marriage? The answer is that the effects in case of absence, defect, or irregularity in the essential or formal requisites of a marriage are found under Article 4 of the Family Code, which provides that the absence of any of the essential or formal requisites shall render the marriage void ab initio, except as stated in Article 35, Paragraph 2. A defect in any of the essential requisites shall not affect the validity of the marriage, but the party or parties responsible for the irregularity shall be civilly, criminally, and administratively liable. Thus, absence of a requisite, whether essential or formal, renders the marriage void. A defect in the essential requisites makes the marriage voidable. An irregularity in the formal requisites does not affect the validity of the marriage, but this is without prejudice to the criminal, civil, or administratively liable of erring officials. Next question is, who are the solemnizing officers? The answer is, the solemnizing officers are provided under Article 7. 1. Any incumbent member of the judiciary within the court's jurisdiction, any priest, rabbi, imam, or minister of any church or religious sect, duly authorized by his church or religious sect, and registered with the Civil Registrar General, acting within the limits of the written authority granted by his church or religious sect, and provided that at least one of the contracting parties belongs to the solemnizing officer's church or religious sect. Number 3. Any ship captain or airplane chief, only in the case mentioned in Article 31. Next is any military commander of a unit to which a chaplain is assigned, in the absence of the latter, during a military operation, likewise only in the cases mentioned in Article 32. Number 5. Any consul general, consul, or vice consul in the case provided in Article 10, and mayors provided under the Local Government Code. Next is, what is the jurisdiction of the members of the judiciary in solemnizing a marriage? As a general rule, the jurisdiction of the members of the judiciary in solemnizing a marriage are found in the following provisions in the Family Code. The incumbent member of the judiciary within the court's jurisdiction, the jurisdiction of the members of the Supreme Court, Court of Appeal Sandigan Bayan, and the Court of Tax Appeal to solemnize marriages is the entire country. On the other hand, the jurisdiction of the RTC judges and judges of MTCs to solemnize marriages is their territorial jurisdiction as defined by the Supreme Court. They must be an incumbent members of the judiciary. Thus, in one case decided by the Supreme Court, it said that on the ground of solemnizing marriage outside of his court's jurisdiction, the respondent judge justified his solemnization of the marriage outside his court jurisdiction under Article 8, provides exemptions that would justify a judge to solemnize that marriage which was outside of his court jurisdiction. Next, thus in Article 8, it provides that marriages can be held outside judges' chambers or courtroom only on the following instances. 1. If the marriage is at a point of death. 2. If it in a remote place in accordance of Article 29, or upon request of both parties in writing in a sworn statement to this effect. Next question is, if a judge of the MTC or the RTC solemnizes a marriage outside of his or her jurisdiction, what is its effect on the marriage? Answer is, the effect on the marriage if a judge of the MTC or the RTC solemnizes a marriage outside of his or her jurisdiction is that where a judge solemnizing a marriage outside his court jurisdiction, this is merely resultant irregularity in the formal requisites laid down in Article 3 of the Family Code. It does not affect the validity of the marriage, but it may subject the officiating officer to administrative liability. Number 9 questions. What are the requisites of authority of the priest, rabbi, imam? The answer is that the requisites for authority of priest, minister, rabbi, imam. First, he must be registered in the office of the Civil Registrar General. 2. He must have a written authority to solemnize marriages given by his church or religious sect. 3. He must act within the limits of such authority. And 4. At least one of the contracting parties must belong to the solemnizing officer's church or religious sect. However, with respect to these 4 requisites for the authority of the priest, ministry, rabbi, or imam, some believe that it is not essential requisites for the authority of priest, ministry, rabbi, or imam. The fact that they are not members, the only irregularity that does not affect the validity of the marriage. When can a consul general, vice consul, consul solemnize a marriage? The answer is, a consul general, vice consul, consul can only solemnize a marriage only if where the marriage is abroad, provided that the marriage abroad is between Filipino citizens in pursuant to Article 10. And Article 10 provides that marriages between Filipino citizens abroad may be solemnized by a consul general, consul or vice consul of the Republic of the Philippines. The issuance of the marriage license and the duties of the local civil registrar and of the solemnizing officer with regard to the declaration of the declaration of the with regard to the celebration of marriage shall be performed by said official or consular official. Also, the consul general, consul, and vice consul can only solemnize marriage between and not also the consul general, consul, and vice consul can only solemnize marriage abroad and not the Philippines. Next question is, when can a ship captain or airplane chief solemnize a marriage? The answer is, any ship captain or airplane chief may solemnize marriage only in the case in Article 31. And Article 31 provides that a marriage in articulo mortis between passengers or crew members may also be solemnized by a ship captain or by an airplane pilot, not only while the ship is at sea or at the plane is in flight, but also during stopovers at ports of call. Any ship captain or an airplane pilot may solemnize marriage only when it is in articulo mortis, and this is further reiterated in Article 31. Next question is, when can a military commander solemnize a marriage? The answer is, the military commander is given the authority to solemnize marriage in case, in the absence of chaplain pursuant to Article 7, marriage may be solemnized by Paragraph 4. Any military commander of a unit to which a chaplain is assigned in the absence of the latter during a military operation, only in articulo mortis between persons within the zone of military operations, whether members of the armed forces or civilians, in pursuant to Article 32. Thus, from the foregoing, the law gives any military commander of a unit the authority to solemnize marriage, provided it is in articulo mortis within the zone of military operations. Next question is, what is the effect of a marriage solemnized in a place or venue other than those provided by law? The answer is that the effect of a marriage solemnized in a place or venue other than those provided for by law is that, as a general rule, the marriage shall take place publicly in the chambers of the judge or in open court, in the church, chapel, or temple, or in the office of the consul general, consul, or vice consul, as the case may be. However, jurisprudence provides that pertaining to where the marriage should take place is merely directory, because the fact that the marriage does not take place in those places enumerated in Article 8 will not affect the validity of the marriage. Next question is, when is a marriage license void? The answer is that a marriage license is void when a marriages that takes place under the family code despite issuance of marriage license, but with respect of the absence of parties in securing marriage license, the defect is that the marriage is void since the law requires personal appearance of both parties in securing marriage license. Thus, absence of parties in securing marriage license is the same as no issued marriage license, which means that marriage solemnized without marriage license is tantamount to a void marriage. Next is number 15 question is that what is the effect of failure to comply with the publication failure to comply with the publication requirements in an application for a marriage license? The answer is that the effect of failure to comply with the publication requirements in an application for a marriage license is that despite issuance of marriage license but without publication are considered mere irregularity that do not affect the validity of the marriage. Thus, issuance of marriage license but without publication are considered mere irregularity that do not affect the validity of the marriage, which means that marriage solemnized with marriage license but without publication is tantamount to avoidable marriage. Number 16. What is the effect if one of the parties to a marriage does not attend and sends a representative to take his or her place and the marriage takes place in the Philippines? Why? The answer is that the effect if one of the parties to a marriage does not attend and sends a representative to take his or her place, and the marriage takes place in the Philippines, is that this situation manifests a proxy marriage. As a rule, if marriage license was issued without the presence of the parties and marriage was solemnized, then the marriage is void since the law prohibits proxy marriage. Next, in other words, marriage by proxy is not allowed in the Philippines because one of the requisites for a marriage to be valid is marriage ceremony, where personal appearance of the contracting parties before the solemnizing officer is a must, and that there must be personal declaration that they take each other as husband and wife in the presence of no less than two witnesses of legal age. Number 17 question is, what is the effect in number 16 if the marriage takes place in another country? In this case, the effect if one of the parties to a marriage does not attend and sends a representative to take his or her place, and the marriage takes place in another country, is that this situation manifests a proxy marriage. As a rule, if marriage license was issued without the presence of the party or parties and marriage was solemnized, then the marriage is valid provided the law of that country allows proxy marriages. As a rule, with respect to proxy marriages abroad, if the marriage is recognized abroad, where under the laws of that country it allows proxy marriages, then our country will recognize it as a valid marriage pursuant to Article 26, Paragraph 1 of the Family Code, where it says that if it is valid in the country where it is solemnized, it will also be considered valid here. 18. When is a marriage license not necessary? In this question, the answer is that a marriage license not necessary in the following instances. 1. Marriage is in articulo mortis. If it is at the point of death, it is solemnized by a ship captain or an airplane chief or a military commander when the marriage is articulo mortis. There is no need for a marriage license for obvious reason because it is a marriage at the point of death. 2. Article 28, where the location of either party is too far from the local civil registrar. If the residence of either party is so located that there is no means of transportation to enable such party to appear personally before the office of the local civil registrar, the marriage may be solemnized without the necessity of a marriage license. Number 3, marriages among Muslims or members of ethnic cultural communities, provided they are solemnized in accordance with their customs, rites, or practice. However, it must be noted that the only thing they are exempted is a marriage license, and the marriage must be solemnized in accordance with their customs, rites, or practice. Next question is, what are the requisites to the 5-year cohabitation rule to apply? The following are the requisites. Or, affidavit of cohabitation is one instance that is recognized pursuant to the case of Manzano versus Sanchez, where in this case the Supreme Court laid down the requisites for the legal ratification of marital cohabitation, and the Supreme Court said that there are 5 requisites. 1. The man and woman must have been living together as husband and wife for at least 5 years before the marriage. 2. The parties must have no legal impediment to marry each other. 3. The fact of absence of legal impediments between the parties must be present at the time of marriage. 4. The parties must execute an affidavit stating that they have lived together for at least 5 years. And number 5, the solemnizing officer must execute a sworn statement that he had ascertained the qualifications of the parties and that he had found no legal impediment to their marriage. Next question is, what is the duty of the local civil registrar in case he is aware of a legal impediment of the applicants to contract marriage? The answer is that if the local civil registrar is personally aware of any legal impediment for the parties to contract marriage, the Family Code provides that the local civil registrar, even if they are aware of a legal impediment of the contracting parties, the local civil registrar must still issue the marriage license because it is the ministerial duty of the local civil registrar to issue the marriage license. The only way the local civil registrar is prevented from issuing marriage license is if it is if it was enjoined by a court order. Next question is that what is the effect of divorce obtained abroad by an alien spouse from his or her Filipino spouse? The answer is the effect of divorce obtained abroad by an alien spouse from his or her Filipino spouse is that, with respect to divorce abroad, if divorce is legal or recognized abroad, where under the laws of that country divorce is legal, then our country will recognize it as valid pursuant to Article 26, Paragraph 1 of the Family Code, where it says that if it is valid in the country where it is solemnized, it will also be considered valid here. Next question, what is the best evidence of a marriage? The answer is that the best evidence of a marriage is a marriage certificate and a marriage license, because a marriage certificate and license are official and public documents, so their validity cannot be successfully assailed except by strong, clear, and convincing oral testimony, such as to the incapacity of one of the parties. In one case decided by the Supreme Court, it held that the solemnization of a marriage without prior license is a clear violation of the law and would lead or could be used at least for the perpetration of fraud against innocent and unwary parties, which was one of the evils that law sought to prevent by making a prior license a prerequisite for a valid marriage. The protection of a marriage as a sacred institution requires not just the defense of a true and genuine union, but the exposure of an invalid one as well. Next question is, what is the effect of failure to sign a marriage contract? The effect of failure to sign a marriage contract may be considered as a mere irregularity, since there is no law which requires that marriage contract to be signed by parties before the marriage is valid. In one case decided by the Supreme Court, it held that failure of the parties to sign the marriage contract will not invalidate the marriage because the law in requiring the signing of the documents are only for the purpose of evidencing the act took place. Question number 24 is, what is the effect of failure to submit a copy of the marriage certificate to the local civil registrar? The answer is that the effect of failure to submit a copy of the marriage certificate to the local civil registrar may be considered as a mere irregularity which does not invalidate a marriage, since it is not one of the ground required by law to invalidate the marriage, provided that all the essential and formal requisites in the solemnization of a marriage are present. Next question is, what is the terminated affinity rule? What is the continuing affinity rule? Which of these two is applied in the Philippines? Alright, so let us answer the first question. The terminated affinity rule view holds or the terminated affinity view holds that relationship by affinity terminates with the dissolution of the marriage, either by death or divorce, which gave rise to the relationship of affinity between the parties. Under this view, the relationship by affinity is simply coextensive and coexistent with the marriage that produced it. Its duration is indispensably and necessarily determined by the marriage that created it. Thus, it exists only for so long as the marriage subsists, such that the death of a spouse ipso facto ends the relationship by affinity of the surviving spouse to the deceased spouse's blood relatives. the On the other hand, the continuing affinity view maintains that relationship by affinity between the surviving spouse and the kindred of the deceased spouse continues even after the death of the deceased spouse, regardless of whether the marriage produced children or not. Under this view, the relationship by affinity endures even after the dissolution of the marriage that produced it as a result of the death of one of the parties to the said marriage. This view considers that where statutes have indicated an intent to benefit step relatives or in-laws, the tie of affinity between these people and their relatives by marriage is not to be regarded as terminated upon the death of one of the marriage parties. The first view admits of an exception. The relationship by affinity continues even after the death of one spouse when there is surviving issue. The rationale is that the relationship is preserved because of the living issue of the marriage, in whose veins the blood of both parties is commingled. Thus, in the following questions, which of these two is applied in the Philippines? It is considered that the continuing affinity rule is adopted in the Philippines. Next question is, who can file a case for declaration of nullity of marriage? Under Section 2 of uh, Administrative Matter Number 02-11-10-SC, a petition of absolute nullity of void marriage may be filed solely by the husband or the wife. Same parties may file in the case of bigamous marriage, wherein the husband or the wife of the prior subsisting marriage is the one who has the personality to file a petition. Next question is, if the purpose to invoke a marriage as void is in order to remarry, what is required? The answer is that if the purpose to invoke a marriage as void is in order to remarry, it is required first to declare the absent spouse presumptively dead based on a well-founded belief. The Supreme Court said in one case it decided that the present spouse must prove that his or her belief is a result of diligence, reasonable effort, and inquiries to locate absent spouse. That based on these efforts and inquiries, he or she believes that under the circumstance, the absent spouse is already dead. It requires exertion of active effort. Jurisprudence provides that a petition to declare absent spouse presumptive death may not be granted. in the absence of any allegation, that the spouse present will remarry. Number 29. What are the requisites for the validity of a subsequent marriage under Article 41? The following are the requisites for the validity of subsequent marriage under Article 41 or valid bigamous marriage. First, that the absent spouse has been missing for 4 consecutive years or 2 consecutive years if the disappearance occurred where there is danger of death under the circumstances laid down in Article 391 of the Civil Code. 2. That the present spouse wishes to remarry, that the present spouse has a well-founded belief that the absent is dead, that the present spouse files a summary proceeding for the declaration of presumptive death of the absentee. Number 30 questions. How is the subsequent marriage under Article 41 terminated? The answer is that the subsequent marriage under Article 41 may be terminated by the recording of the affidavit of reappearance of the absent spouse in the civil registry of the residence of the parties to the subsequent marriage, shall automatically terminate the subsequent marriage, unless there is judgment annulling the previous marriage or declaring it void ab initio. In one case, the Supreme Court held that no judicial proceeding to annul a subsequent marriage contracted under Article 41 is necessary. Also, the termination of the subsequent marriage by affidavit provided for in Article 42 does not preclude the filing of an action in court to prove the reappearance of the absentee and obtain a declaration of dissolution or termination of the subsequent marriage. Question 31. What if A had a well-founded belief that B was already dead when he filed the petition for declaration of presumptive death and later married X? However, X was aware of the whereabouts of B. What is the status of the marriage of A and X? The answer is that the status of the marriage of A and X is valid because the present spouse proved based on the requisites for issuance of judicial declaration of presumptive death and that A's claim to declare the absent spouse presumptively dead was based on a well-founded belief. Jurisprudence provides that the declaration of presumptive death is without prejudice to the effect of reappearance of the absent spouse. The declared presumption will still only be prima facie and can be overthrown by evidence. And that the recording of the affidavit of reappearance of the absent spouse in the civil registry of the residence of the parties to the subsequent marriage shall automatically terminate the subsequent marriage. However, if the absentee reappears but no step is taken to terminate the subsequent marriage, either by affidavit or by court action, such absentee's mere reappearance, even if made known to the spouses in the subsequent marriage, will not terminate such marriage. 32. When do we determine the good faith or bad faith of the spouses to the subsequent marriage under Article 44 of the Family Code? The answer is that we determine the good faith or bad faith of the spouses to the subsequent marriage must be present up to the time of the celebration of the subsequent marriage. This means up to the solemnization of the subsequent marriage. Question number 33. What is the distinction between Article 45, Paragraph 6 and Article 46, Paragraph 3? The distinction between Article 45, Paragraph 6 and Article 46, Paragraph 3 is that under Article 45, Paragraph 6, it is a ground for annulment, while the latter were concealment of STD regardless of its nature existing at the time of the marriage will constitute fraud. Another is under Article 45, Paragraph 6, the STD existing at the time of the marriage must be found to be serious and appear to be incurable, to be a ground for annulment. It must have been concealed by the sick party. It is the fraud that is the ground for annulment. Question number 34. What is the effect of reconciliation of the spouses where a case for legal separation is pending between them? The answer is that the effect of reconciliation of the spouses where a case for legal separation is pending between them is that if the spouses should reconcile, a corresponding joint manifestation under oath duly signed by them shall be filed with the court in the same proceeding for legal separation. The legal separation proceedings, if still pending, shall thereby be terminated at whatever stage. Number 35. What is the default regime under the new civil code? What about under the family code? Default regime refers to absolute community of property, which is a special type of co-ownership. Hence, the Supreme Court held in one case that the default regime of the husband and wife are all properties of the marriage, which means that whatever property of each spouse brings into the marriage and those acquired during the marriage, except those excluded under Article 92 of the Family Code. The default regime under the new Civil Code is conjugal partnership of gains. Under Article 119 of the new Civil Code states that in the absence of marriage settlements or when the same are void, the system of relative community or conjugal partnership of gains as established in this code shall govern the property relations between husband and wife. But under the Family Code, the default regime is absolute community of property under Article 75 of the Family Code states that in the absence of a marriage settlement or when the regime agreed upon is void, the system of absolute community of property as established in this code shall govern. Next is that what is a donation propter nuptias? Donation propter nuptias refers to donations by reason of marriage which are made before the celebration of the marriage in consideration of the same and in favor of one or both of the future spouses in relation to Article 82 of the Family Code. Question number 37. What is the effect of a donation propter nuptias if the marriage is not celebrated? The answer is that the effect of a donation propter nuptias if the marriage is not celebrated is that the donation propter nuptias may be revoked by the donor if the marriage is not celebrated. Number 38. What properties are included in the absolute community property? Answer: the absolute community of property encompasses all the properties each spouse owns at the time of the marriage and thereafter. Next question is, what properties are excluded in the SCP? The answer is that the following are the properties that are excluded in the absolute community of property. 1. Property acquired before the marriage by either spouse which has been excluded from the absolute community in the marriage settlement. Property acquired, or number 2, property acquired during the marriage by gratuitous title by either spouse, and the fruits as well as the income thereof, if any, unless it is expressly provided by the donor, testator, or grantor that they shall form part of the community property. Next question. When does the conjugal partnership of gains commence? The answer, conjugal property of gains commence at the precise moment that the marriage is celebrated. Any stipulation expressed or implied for the commencement of the regime at any other shall be void, in the same manner as to absolute community of property. Next question. What are the properties included in the conjugal partnership of gains? The answer, the following are the properties included in the conjugal partnership of gains. 1. The proceeds, product, fruits, and income of their separate properties, those acquired by either or both of them through effort and chance. Question number 42. What relationships will fall under Article 148 of the Family Code? The answer is that Article 148 of the Code refers to the property regime of bigamous marriages, adulterous relationships, relationships in a state of concubinage, relationships where both man and woman are married to other persons, multiple alliances of the same married man. Article 48 or 148 also applies when the common law spouses suffer from a legal impediment to marry or when they do not live exclusively with each other as husband and wife. Next question is, what are the relationships that will fall under Article 148 of the Family Code? Article 148 of the Family Code refers to the property regime of bigamous marriages, adulterous relationships, relationships in a state of concubinage, relationships where both man and woman are married to other persons, multiple alliances of the same married man. Article 148 also applies when the common law spouses suffer from a legal impediment to marry or when they do not live exclusively with each other as husband and wife. Question 44. How is a family home constituted under the Civil Code? What about under the Family Code? The answer, under the Civil Code, the family home is constituted judicially or extrajudicially. In a judicial constitution, the family home may be constituted by a verified petition to the court of first instance by the owner of the property and by approval thereof by the court. In extrajudicial constitution, the family home may be constituted by recording in the civil registry of property a public instrument, wherein a person declares that he thereby establishes a family home, but but I mean in an extrajudicial constitution, the family home may be constituted by recording in the registry of property a public instrument, wherein a person declares that he thereby establishes a family home out of a dwelling place with the land on which it is situated. Under the family code, the family home is deemed constituted on a house and lot from the time it is occupied as a family residence, from the time of its constitution, and so long as any of its beneficiaries actually resides therein, the family home continues to be such and is exempt from execution, for sale or attachment, except as hereinafter provided, and to the extent of the value allowed by law. Question 45. What are the exceptions to the rule under Article 155 for a family home being exempt from execution, etc.? The family home shall, as a general rule, exempt from execution, for sale or attachment, except debts in 1. Debts incurred due to laborers, mechanics, architects, builders, material men, and others who rendered service or furnished materials for the for the constitution of the building. B. Non-payment of taxes. C. Debt incurred before the constitution of family home. D. Debt secured by mortgages on the premises before or after the constitution of family home. 46 question. Who can constitute a family home? The following are the beneficiaries of a family home. 1. Husband and wife. 2. Unmarried head of the family. 3. Parents. 4. Ascendants. 5. Descendants. 6. Brothers and sisters. Who can constitute a family home? The law provided that a family home can be constituted by the spouses on their own conjugal or absolute community property, and an unmarried head of the family home on her own property. On what properties can the family home be constituted? Under the family code, it provides that family home is constituted only on real property. The family home is deemed constituted on a house and lot from the time it is occupied as a family residence. And number 49, who are considered legitimate children? The answer is that legitimate children are those conceived or born during the marriage of the parents, including children born of marriages which are declared void under Article 36, and children born of marriages which are declared void under Article 53. Who are considered illegitimate children? The following are considered illegitimate children. 1. Children conceived and born outside a valid marriage. 2. Children born of couples who are not legally married or of common law marriages. 3. Children born of incestuous marriage. 4. Children born of bigamous marriage. Number 5. Children born of adulterous marriage relations between parents. Children born of marriages which are void for reasons of public policy under Article 38 of the Family Code. And number 7. Children born of couples below 18. Below 18. Children born of void marriages under Article 35, except where the marriage is void for lack of authority on the part of the solemnizing officer, but the parties or either of them believe in good faith that the solemnizing officer had authority, in which case the marriage will be considered valid and the children will be considered legitimate. Question number 51. What kind of children may be legitimated? Children that may be legitimated are those who in fact not born in wedlock and should therefore be ordinarily illegitimate are by fiction considered legitimate. It takes place by a subsequent valid marriage between parents, or only children conceived and born outside of wedlock of parents who, at the time of conception, were not disqualified by any impediment to marry each other, or where is disqualified only because either or both of them were below 18 years of age. Number 52. Who may attack the legitimacy of a child within what period? Legitimation may be impugned only by those who are prejudiced in their rights within 5 years from the time their cause of action accrues, that is, from the death of the putative parent. When may the action to claim legitimacy be brought? As a general rule, the action to claim legitimacy be brought or the right of claiming legitimacy belongs to the child, except when the right is transferred to his heirs when the child dies during minority or in a state of insanity after commencing the action for legitimacy. Question number 54. What are the rights of a legitimate child? The answer is the following are rights of legitimate children. Legitimate children have the right to use the surname of the father. Number two, they have the right to receive support. Number three, and they have successional rights such as being compulsory heirs with respect to their legitimate parents and ascendants, and they remain as in the state of heirs or legal heirs of their parents and other ascendants. Next is, what are the rights of an illegitimate children? The answer is that the following are the rights of an illegitimate child are as follows. 1. They shall use the surname of the mother. 2. They shall be under the parental authority of the mother. 3. They shall be entitled to support in conformity with the family code, provided only as to the separate property of the parent. Number 4. They shall be entitled to a legitimate which shall consist of one half of the legitime of a legitimate child. Number 56 question. Who shall have parental custody of an illegitimate child? The answer is that illegitimate children shall be under the parental authority of their mother, provided under Article 176 of the Family Code, which states that illegitimate children shall be under the parental authority of the mother, but this applies in two cases: where the paternity of the child is unknown or in doubt, and number two, where the paternity is certain, the father is not living with the mother and child. Number 57. When can an illegitimate child use the surname of his illegitimate father? An illegitimate child may use the surname of his illegitimate father provided under Article 176 as amended by Republic Act No. 2955, which states that the illegitimate children may use the surname of their father if their filiation has been expressly recognized by the father through the record of birth appearing in the civil register, or when an admission in a public document or private handwritten instrument is made by the father. And number 58 questions, can an illegitimate child be compelled to use the surname of his or her illegitimate father who has recognized said child? The answer is that No. An illegitimate child cannot be compelled to use the surname of his or her legitimate father who has recognized said child because of Republic Act 9255. This act provides that illegitimate children may optionally use the father's surname provided that filiation has been recognized by the father through the record of birth appearing in the civil register. Admission number 2, admission in public document or private handwritten instrument is made by the father. Question number 59. What is the parental preference rule? Parental preference rule provides that a natural parent, father or mother, as the case may be, who is of good character and a proper person to have the custody of the child and is reasonably able to provide for such child, ordinarily is entitled to the custody as against all persons. Accordingly, such parents are entitled to the custody of their children as against foster or prospective adoptive parents, and such entitlement applies also as against the relatives of the child, including grandparents or as against an agency or institution. Next question is, what is the maternal preference rule? In this case, the maternal preference rule provides that a child under 7 years of age shall be in custody of the mother, and it is universally recognized that the mother is the natural custodian of the young. The law favors the mother if she is a fit and proper person to have custody of her children so that they may not only receive her attention, care, supervision, and advice, but also may have the advantage and benefit of a mother's love and devotion for which there is no substitute. Question number 61. What is the special parental authority rule? The answer is that the special parental authority rule can be found under Article 218, which provides that the persons and entities given by law special parental authority are the school, its administrators and teachers, or the individual, entity or institution engaged in the child care. They are civilly liable for acts and omissions of emancipated minors. However, the liability shall not apply if they prove that they exercise the proper diligence required under particular circumstances. The liability is still attached while the minor child is under their supervision, instruction, and custody, and also to all authorized activities inside the premises of the school. Question number 62. What is substituted parental authority? The substituted parental authority refers to the parental authority which the persons designated by law may exercise over the persons and property of emancipated children in case of death, absence, or unsuitability of both parents, or in default of a judicially appointed guardian. Question number 63. Who is legally available for adoption? Or maybe it means who is legally available for adoption. Legally available for adoption refers to a child voluntarily or involuntarily committed to the DSWD as dependent, abandoned, or neglected pursuant to the provisions of the Child and Youth Welfare Code may be subject of inter-country adoption, provided that in case of a child shall be made not earlier than 6 months from the date the deed of voluntary commitment was executed by the children's biological parents. A legally free child is 3 is freed of his biological parents, guardians, or adopters in case of rescission. Question number 64. When can a married person adopt on his or her own? A married person may adopt on his or her own child in pursuant to the Domestic Adoption Act and the Family Code. Both require a joint adoption by the husband and wife, provided that it is mandatory for both the spouses to jointly adopt, except in 3 instances. If one spouse seeks to adopt the legitimate son, daughter of the other, or if one spouse seeks to adopt his or her own illegitimate son or daughter, provided, however, that the other spouse has signified intention his intention or provided, however, that the other spouse has signified his or her consent thereto. Or number 3, if the spouses are legally separated from each other. Number 65, who and under what instances can an adoption be rescinded? The answer is that the adoptee has the sole right to sever the legal ties created by adoption, and the one who will file the action for rescission. However, if the adoptee is still a minor or above 18 years of age but incapacitated, the Department of Social and Welfare Development, as the adoptee's guardian or counsel, may assist the adoptee for rescinding the decree of adoption. Upon petition of the adoptee, with the assistance of the DSWD, if a minor or if over 18 years of age but is incapacitated as guardian counsel, the adoption may be rescinded on any of the following grounds committed by the adopter. First, repeated physical and verbal maltreatment by the adopters despite having undergone counseling, attempt on the life of the adoptee, sexual assault or violence, abandonment and failure to comply with parental obligations. Next question is that whose consent to adoption is necessary? The following are those whose consent is necessary to the adoption under domestic adoption. 1. The adoptee, if 10 years of age or over, the biological parents of the child, if known, or the legal guardian or the proper government instrumentality which has legal custody of the child. Number 3, the legitimate and adopted sons, daughters, 10 years of age or over of the adopters and adoptee, if any. Number 4, the illegitimate sons, daughters, 10 years of age or over of the adopter, if living with said adopter, and the latter's spouse, if any, and the spouse, if any, of the person adopting or to be adopted. The following are those whose written consent is necessary for adoption in inter-country adoption. 1. Written consent to the adoption in the form of a sworn statement by the biological and or adopted children of the applicants who are 10 years of age or over, to be attached to the application filed with the Family Court or Inter-Country Adoption Board. 2. If a satisfactory pre-adoptive relationship is formed between the applicant and the child, the written consent to the adoption executed by the DSWD is required. Number 6. Excuse me. What are the effects of adoption? The answer is that, as a general rule, the effects of adoption is that the severance of all legal ties between the biological parents and the adoptee, and the same shall then be vested on the adopters, except in the following cases: 1. Where the biological parent is the spouse of this adopter. Number 2, deemed a legitimate child of the adopter. 3. Acquires reciprocal rights and obligations arising from parent-child relationships. Number 4. Right to use surname of adopter. Number 5. In legal and intestate succession, the adopters and the adoptee shall have reciprocal rights of succession, which distinction from legitimate filiation. However, if the adoptee and his or her biological parents had left a will, the law on testamentary succession shall govern. Number 68. What are the effects of the rescission of adoption? Answer: the effects of rescission of the adoption under the Domestic Adoption Act of 1998 are the following. 1. If adoptee is still minor or is incapacitated, restoration of parental authority of the adoptee's biological parents if known, or custody of the DSWD. Number 2, reciprocal rights and obligations of the adopters and adoptee to each other shall be extinguished. Court shall order the civil registrar to cancel the amended certificate of birth of the adoptee and restore his or her original birth certificate. Number 4, suspension succession. Succession rights shall revert to its status prior to adoption, but only as of the date of judgment of judicial rescission. 5. Vested rights acquired prior to judicial rescission shall be respected. 69. Who are obliged to give support? The answer is the following are those who are obliged to give support in pursuant to Article 195. 1. The spouses. 2. Legitimate ascendants and descendants. 3. Parents and their legitimate children and the legitimate and illegitimate children of the latter. Number 5. Legitimate brothers and sisters, whether of the full or half blood. Article 196. Brothers and sisters not legitimately related, whether of the full or half-blood, are likewise bound to support each other to the full extent set forth in Article 194, except only when the need for support of the brother or sister being of age is due to a cause imputable to the claimant's fault or negligence. Question number 70 is that what is the other order of liability to give support when two or more persons are obliged to give support? The answer is that the order of liability to give support when two or more persons are obliged to give support, as a general rule, whenever two or more persons are obliged to give support, the liability shall devolve upon the following persons in the following order. First, the spouse. Second, the descendants in the nearest degree. Third, the descendants in the nearest degree. And fourth, the brothers and sisters in pursuant to Article 199.